Y'all, Mounk Tounk, he going to jail. Today, Judge Whitaker ruled on the state's motion to revoke the probation of Mounk Tounk, aka Antonio Sledge, and ultimately Judge Whitaker decided to grant the state's motion and to revoke Mr. Sledge's probation. Let's talk about it.
Give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And
And he will be continued on probation, Your Honor?
And reinstate the balance.
Thank you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry. All right, court is adjourned.
Hi, my name is Rochelle and I'm an attorney. Even though I'm an attorney, I'm not your attorney. This video is for entertainment purposes only. It is not legal advice. As I alluded to in my intro, the prosecution a few weeks ago filed a motion to have Antonio Sledge, aka Mounk Tounk's probation revoked because of his failure to comply with the terms of his plea agreement that was entered into back in December of 2022. Now, if you recall, when I made a video about Mounk Tounk and his testimony, I kind of indicated that, hey, I think the state's going to try to violate him because during his testimony, he said that even though in his plea agreement, he made certain factual acknowledgments and indicated that he had reviewed the statements that he was initialing and that he agreed to them and that they were truthful. When he was on the stand, he said the exact opposite of that in many instances. And ultimately, Judge Whitaker, when she made her ruling today, indicated that ultimately Mounk Tounk has perjured himself. And for that reason, she had made the decision to grant the state's motion and to ultimately revoke his probation for 5 years. So Mounk Tounk is unfortunately headed to jail. Now, let's talk about some of the arguments advanced by Mounk Tounk's counsel in this hearing. So, once the judge kind of indicated at the beginning that, hey, I'm going to grant the state's motion, Mounk Tounk's attorney had an opportunity to be heard on the issue. And so let's kind of break down what he was arguing. So first, he argued that in his view, Mounk Tounk's violation of probation should be seen as a technical violation of his probation as opposed to a substantive violation of the probation. So what does that even mean? So a technical violation of probation, it happens when someone doesn't comply with the terms of their plea agreement, but they have not committed any new crime. So example is, if someone tests positive on a drug test, if they fail to pay fines or restitution, if they've been sentenced to community service, but they haven't done so, if they were required to attend certain programs or get a job and they didn't do that. Those are terms of a person's probation, and if they don't follow them, that is a violation of the terms of their probation, but it is not them committing a new crime, be it a misdemeanor or a felony. So generally in Georgia, if a person has a technical violation of probation, the judge can ultimately decide what the punishment will be for that violation, but generally they cannot be sentenced to more than 2 years, right, in jail for a technical violation of their probation. Now, a substantive violation of a probation is just what you think. It's when a person commits another crime, be it a misdemeanor or a felony. Now, when this occurs, the judge can ultimately decide, what the penalty will be for that. And obviously the penalty for that would be generally greater than, 2 years. So the reason that Mr. Sledge's attorney is arguing, hey, if it's a violation of probation, I think this is a technical violation of probation because Mr. Sledge did not commit a new crime. So the judge rejected this argument, and she indicated that in her view, Mr. Sledge not abiding by the terms of the plea agreement ultimately is not a technical violation, but is a substantive violation because in her view, his testimony at trial was perjury. So then you say, okay, well, how could his testimony be perjury? Ultimately, if you believe that Mounk Tounk is telling the truth at the time that he testified at trial, how can that be considered perjury? Let me explain to you why. So back in December of 2022, when Mounk Tounk took the plea deal, he acknowledged on the record in front of the court, in front of the attorneys, that he had reviewed the factual statements, that he had reviewed the acknowledgments, that he understood what those things mean, and he agreed with those statements by initialing those statements when he signed off on the plea agreement. Now, when he testified at trial, he said that certain statements in that agreement, number one, that they were not true to his knowledge, and he also indicated that there were statements that he did not review prior to signing off on them during that plea hearing back in December of 2022. So Judge Whitaker saying that he committed perjury is her saying that back in December of 2022, when he signed off on these statements, saying that they were true, saying that he had reviewed them, saying that he understood them, that was not true based upon his testimony at trial. And so given that those statements that he made under oath and by signing that agreement were not true, then he committed perjury at that time. And so now the penalty for that is her revoking the terms of his probation and ultimately sending him to jail for 5 years. His attorney also attempted to submit argument to the judge indicating that, Mr. Sledge had not committed any additional crimes, that he recently became a grandfather and is, welcoming another grandchild sometime in the near future. And while the judge commended him on not committing any more crimes and seemingly moving forward with his progress, she still ultimately decided to violate his probation for a term of 5 years. So that's the result that we have for today. Unfortunately, we see Mr. Sledge being put in handcuffs, and presumably he will be taken into custody today to begin to serve the 5-year time that he got. Now, also in the beginning of this hearing, they were trying to calculate exactly how much time Mr. Sledge has left on his sentence in the terms of the plea agreement. He was sentenced to 30 years. And so some of that time was commuted, and some of the time he got time served for the combination of, time that he spent incarcerated after he was initially arrested back in 2022, and also time that he served while on probation under the terms of the plea agreement. So he got credit for a couple of years, and they indicated that the time remaining on his sentence is 27 years, 8 months, and 7 days. So that's how much time he has left, on that sentence. They're going to revoke him for a period of 5 years. So unclear how much of that time he'll actually end up having to serve in custody. But as of today, Mr. Sledge has been taken into custody. So I hope, that was a good breakdown of exactly what happened and kind of the court's reasoning in terms of why Mr. Sledge was violated and why she viewed his testimony in this case to be perjurious testimony. And that's why, we got the result that we got today. So thank you so much for watching this video. Please don't forget to like, comment, subscribe, and I will see you in the next video.